Good afternoon, everybody. Can everyone hear me? Okay. Well, I'd like to welcome everybody to the January 2022 Administrative Committee meeting. Before we get started, I'd like to recognize we have some new members of the committee, new council members. We have Ms. Tamika Shafiq Horton from District 26. We have Jonathan Herring from District 9, Greg Jones from District 27. And I apologize if I mispronounce anybody's name. George, is it Loughran from?
Lauren, close enough, that's okay.
Okay, from down in Mecklenburg County. We have Miss Mary Oxley from way out west, District 41. Good afternoon. We have Michael Peters from District 8. And I believe it's Zaylin McKinney from Murphy. Well, welcome all the new members. It's good to see old faces. I'm looking forward to being able to meet everybody in person, hopefully in April. But before we get started, let me just give the standard admonition that prefaces every meeting. Members of the committee are hereby advised of their duty under the State Government Ethics Act to avoid conflicts of interest and the appearance of conflict, and are instructed to refrain from participating in any manner coming before this committee with respect to which there is a conflict of interest or appearance of conflict. Is there any member of the committee that perceives they have either a conflict or an appearance of a conflict for the matters on our agenda? Okay. I'd also note that this meeting is being live streamed. What we are on YouTube, so what we say today is being preserved for posterity. Turning to Roman numeral 1, a review of the administrative committee procedures. Does anyone have any questions, concerns about our procedures which were included in the material?
Richard, I'll just, this is Peter. I'm one of the staff counsel to the committee, and these procedures are in your materials. There's a lot of information in there, but in general, you know, we are tasked with essentially dealing with the administrative matters that come before the bar. People who are seeking to go inactive or change their status to be reinstated from inactive or administrative suspension status, to people who are potentially subject to getting notices to show cause or suspensions for failure to pay dues or failure to complete CLE requirements, failure to pay district bar dues. We review district bars, bylaw amendments. We deal with suspensions for failure to file CLE annual report forms, potential waiver requests, really kind of all those types of administrative matters. I think you will get the hang of it pretty quickly if you're new to the committee on what we deal with. And as we go through the agenda on each one of these items, I'm happy to explain in further detail what these items mean as we go through the process today. Might be the best way to learn what's happening is we can kind of go by item here, so you can learn you know, what this particular topic is all about.
And turning to Roman numeral 2, the report of the last committee meeting in October of 2021, that was included in your agenda. I don't believe there's really anything to discuss about that. So we will move to the Roman numeral 3. These are petitions attorneys have filed seeking inactive status, where the applicants have fulfilled all of the requirements. Typically, we will vote on these petitions as a group. Does anybody have any questions or comments regarding Roman numeral 3?
So just as an FYI to the new committee, the January meeting is the meeting in which we get the most petitions for inactive status, because if you become inactive through the January meeting, you are not required to pay this year's dues. And so you get a lot of lawyers who wrap up their year, the prior year, and then seek inactive status to keep them from having to pay the 2022 dues. And so that's why we have 161 who have petitioned for inactive status, who fulfilled their requirements, and then another 25 who have not fulfilled the requirements. And I suppose, Mr. Chair, we want to start with Roman numeral 3A and then go to B.
Yes.
Okay.
Okay. So with Roman numeral 3A, these are the folks that are petitioning to go inactive. They have fulfilled all of the requirements. And I would entertain a motion.
A motion that they be approved.
Do I hear a second?
Second.
Okay,
May I ask a question?
absolutely.
This might be kind of a silly question, but 3A number 5, is the bar number really 20? That mean,
I believe they began reusing bar numbers at one point.
That's right. It's not purely chronological anymore. There was a time period where some bar numbers were reused. It's not anymore. We don't reuse them anymore, but there was a period where we reused bar numbers. And so if this really is number 20, it is not the 20th lawyer that we had in the history of North Carolina.
okay, thank you.
Kathleen, we have not done that since 1993, when my predecessor became the executive director. That was discontinued at that point in time, and everyone after that gets a number that's sequential.
Thank you.
Rich, I have one more question, if I
Sure.
may. I'm first day, so I don't want to mess up already, but one of the names on 3B is a family member of mine. I don't know that that's a conflict of interest, but I felt like I should mention it at least.
Is that's on 3B?
3B, yes.
Okay. I don't perceive it to be. I mean, when typically for the folks that are petitioning for an active status that they owe a nominal amount of bar dues, we will conditionally grant the petitions, provided that they fulfill the requirements by the next meeting.
Yeah, I would advise that this is not something that you would need to recuse yourself from, since it's a pretty straightforward administrative matter.
Sure. Thank you.
So we have a motion that's been seconded. Any further questions or comments? Okay, so you should have a poll that popped up.
Rich, that's unanimous.
Okay. The motion carries. Now, turning to Roman numeral 3B, these are the folks, as you can see, they have small amounts of money that they owe that typically we would grant their petitions for an active status, provided that they fulfill the requirements by the April 2022 meeting. Does anyone have any questions or comments about Roman numeral 3B? I'll entertain any motions.
Move to approve.
Okay. We have a motion and a second. Are there any questions or comments?
This is a motion to approve upon fulfilling the noted conditions by the April
Yes.
22. All right.
Peter, can I ask a question?
Sure.
What happens if they don't fulfill it? I'm a new member. What happens if they don't fulfill it by the April meeting? Does it get carried over to the July meeting?
Yes. Yeah. I mean, at that point, then, there's a strong likelihood that they will have to pay their dues. if they've been practicing during that time frame. They might be able to request a nunc pro tunc kind of dating back type of thing. But we really, in this situation, we're trying to give them the one meeting leeway, and otherwise might have to be denied.
Thank you.
Any other questions or comments?
That is, it's unanimous.
Okay. Turning to Roman numeral 3C, these are folks that are applying for an active status, both applying for an active status nunc pro tunc to December 31st of 2020, which would allow them to avoid paying dues assessed after that date. I would say in general, we have folks that apply and seek nunc pro tunc status. Typically, they're lawyers that have had some, fairly significant health problems or other circumstances that prevented them from filing a petition in a timely manner. Unless I hear any differently, I'd like to address each petition individually, beginning with Mr. Brooks. That is Roman numeral 3C subsection 1. And Mr. Brooks is seeking nunc pro tunc status to December 31st of 2020. Does anyone have any questions or comments on Mr. Brooks' petition?
For the new members, one of the conditions for being able to receive nunc pro tunc status is that you have not practiced law since from the period in which you're seeking that nunc pro tunc status. So, for example, Mr. Brooks has not practiced law since June of 2020, so it would not be an issue to get that nunc pro tunc back to December of 2020.
And I think in the materials, it indicates that he had a stroke in June of 2020, and he's been in a long-term care facility ever since then.
So I would move that we grant his request nunc pro tunc to December 31st of 2020.
Okay. And is there any second to Judge Rader's motion? Okay. We have a motion and a second. Any questions or further comments? To grant Mr. Brooks' motion nunc pro tunc to December 31st of 2020.
That appears to be unanimous, Rich.
Okay, thank you. Now, turning to Judge Chess's petition, he is seeking the same status. He reached out to Tammy Jackson and is seeking nunc pro tunc status. And what I noticed in reading the materials, it indicates that he wrote a letter seeking an active status. And Tammy, sometimes do you have attorneys that, due to whatever issues with like cognitive decline, they may have difficulty filling out the application, and they'll have either a caregiver or somebody send a letter or an email seeking nunc pro tunc status?
Yes, that's correct. I've spoken with Judge Chess many times, and I did send him the petition, and I would call to follow up, but I really just think he was having trouble kind of following through. As a matter of fact, I kind of seriously doubt he even wrote the little correspondence that we received. I'm sure maybe someone did on his behalf. Some mighty neat handwriting for someone that's almost 90 years old, but and he is almost 90. And I did call him a few days before the meeting, and I just confirmed that this was his wishes, and that we never received his petition, but maybe that you would or the committee would accept the letter in lieu of a petition. And he was very grateful. And this is what he wants to do. It's just he's having trouble actually getting the petition to us.
All right. Thank you, Tammy.
Mhm.
Josh Malcolm, move to approve.
Okay, so we have a motion. Is that to approve nunc pro tunc to 12/31/2020?
Yes, sir.
Okay, thank you, Josh.
Second that.
Okay, so we have a
Judge
motion.
Kenneth,
and
you
a
have your hand
second.
raised.
Well, sort of halfway, kind of. He was a colleague and family friend, but I must say we did not communicate outside of the workplace, and he retired 10 years ago. So I feel very comfortable voting if you have no problem with me voting for it, and I understand his circumstances.
No, I think that is still appropriate for you to vote. Yeah.
Thank you.
Rich and Peter, would we have to accept the letter in lieu of the petition first before we call the question?
I don't think we have to. I think we can, the committee can grant the nunc pro tunc status.
Thank you.
Any additional questions or comments? Okay, I'll call the question.
That's unanimous.
Okay, the motion carries. Next is Roman numeral 4, which are petitions for reinstatement from inactive status, specifically 4A, that have been approved by the secretary. It's nothing for us to act on.
So just as an FYI to new members, we can, if someone has been inactive for a period of time and has fulfilled all their requirements, they can be reinstated in between quarters by the secretary, so it doesn't have to go to the committee for its decisions if there are no issues. I mean, it's just discretionary by the secretary, but assuming there are no issues and that there's no concerns and all the requirements are met, then they can be reinstated in between quarters.
Roman numeral 4B is Mr. Miller's petition, and he is seeking, well, he was granted nunc pro tunc status December 31st of 2024 due to health issues. And in petitioning for reinstatement, he would have been required to take, I believe it's 12 hours of CLEs for every year that he was inactive. He has completed 68.5 hours. He still needs 11.5 hours of CLE classes to take, along with 3 letters with his petition, which needs to be notarized. So he is seeking reinstatement. Gave a fairly detailed letter about his circumstances and the materials. It looks like he's been driving for Uber Eats and DoorDash and has been living a very solitary existence over the last several years. So he is seeking to be reinstated. We can approve his petition upon satisfying the requirements noted in the agenda, or defer consideration to the April 2022 meeting, deny the petition, or adopt some other relief. So I'd open the floor to any questions or concerns about Mr. Miller's petition.
Rich, this is Tammy. If I could say, he did email yesterday the signed page, the notarized page of his petition. So I do have that.
Okay. One of the questions I had in reviewing his material, he sounded like he would have difficulty getting 3 people to vouch for him. He said he just doesn't really have any interaction with people.
he has expressed those concerns often, but he is going to reach out to maybe
Okay.
some colleagues at the university where he did some teaching. And I told him if he could, someone that he had a business relationship with, maybe, or similar to maybe not necessarily other NC attorneys, because sometimes that happens if they've been out of the workforce for a long time.
Did you get a sense that he would be able to comply by April 2022 with the letters and the CLE requirements?
I did. He's real close to completing the CLE, so I think he'll have all of this accomplished
Okay.
really before the April meeting.
Okay. Any questions, concerns about Mr. Miller's petition? Any motions?
Move to approve upon satisfying the noted requirements.
By the April 2022 meeting?
My motion was that we approve it when he meets the noted requirements rather than deferring it to the April meeting.
Okay,
And I second that.
okay. Does anybody have any additional comments or concerns? Okay. I think we're ready to vote.
Unanimous.
Next is Roman numeral 4C, section 1. That is Mr. Green. Mr. Green went inactive in January of 2013. And he filed a petition seeking to return to active status without having to take the bar examination. His letter and his materials, there's some material from, I believe, his psychologist indicating that he suffered a traumatic brain injury in 2012. He was in a coma for a number of months. He's had to have multiple surgeries. He suffered from seizure conditions and PTSD over the last several years, but apparently has gotten his health physically and mentally returned to him to some extent. Peter, was it in 2011, a requirement was enacted that if you've been inactive for longer than 7 years, you would be required to take the bar examination again?
Yes, that rule was put in place in 2011. And so part of what we can talk about in the next item, but recently we removed there was language in that rule that said effective for anyone, inactive after 2011, the bar exam requirement was in place, but it was grandfathered in. People who were inactive prior to 2011 were not required to take the bar exam. They could take the CLE hours instead. So this past year, when we amended that rule, because we wanted to make them add the MPRE requirement and the UDE language in there, we eliminated the grandfathering language. So there is no 2011 cutoff. It's anyone who is inactive for more than 7 years has to take the bar exam to come back in instead of the completing CLE hours.
Okay. Did the committee address a similar petition last year where someone was allowed to come back to active status without taking the bar examination, just taking the CLE requirements?
Rich, I can recall, it was a gentleman, yes, the committee did vote to allow him to do the CLE. And his circumstances was not health related, but it was during COVID 2020, ran the family business, restaurant business, and was really focused on keeping that afloat at the time. So that's been an exception.
Okay. And if memory serves me, his petition was filed maybe if he would have filed it a few months earlier, he would have fallen within the 7-year window where he wouldn't have had to taken the exam.
I think that's exactly right. And in Mr. Green's situation, I guess if he had filed it, I think by January 2020, I believe. So I believe that's right. The date.
Is this the second petition this committee has had where someone is seeking a waiver of the bar exam requirement? The reason I ask, I don't recall us addressing this issue with the exception of last year.
Yeah, I don't know. I mean, I honestly can't recall. If it was, it's not related. They weren't related to the grandfathering issue. It was just someone didn't want to take the bar exam. But I don't have a memory in my head of that being a request that we've dealt with. Okay. If we've dealt with it, it must, very, very few times. It's not a common thing.
Okay.
Well, the grandfather clause, even if it were in effect, wouldn't apply to him.
No, that's correct.
He went in 2013, correct?
That's correct. Yeah, he's not a victim to the grandfather clause. That's right.
But the previous individual who we were talking about by way of comparison, was that a grandfather clause issue?
No, ma'am.
Okay, and can you then just repeat, you said it was a few months delay in filing, and this individual, so it's about a year. I'm just trying to make sure I understand the difference between the two petitions.
Yeah, the individual from last year, it was only a matter of 1 or 2 months, I believe, that during the heart of COVID, that if they had gotten the petition in before that, it would have been within the 7-year time frame. And in this Mr. Green situation, the letter and the materials seem to indicate that the health prevented him from being able to get it in timely, but that is the will of the committee on this one. It's not as close of a cutoff as the one from last year, but potentially the circumstances might be more compelling.
So just to be clear, if we approve his petition, he would be relicensed only upon completing 84 hours of CLEs and the other membership requirements and reinstatement fees.
That's correct.
That's correct.
If you approve his request to be able to do that in lieu of the bar exam. That's right.
Mr. Chair, in looking at the materials that Mr. Green submitted, I didn't see something consistent with what we saw with the individual last year who, because of the craziness of COVID right when it hit, had missed his application period by a short period of time. It was weeks, I think, maybe 2 months. And here we've got someone who would have had to make his application by January of 2020, and his request is dated the end of October of 2021, so almost 2 years later. And I don't see anything in his letter that indicates why he's unable to take the bar exam or would want to be accepted from it, other than that he does not want to take the bar exam. It was obvious that his medical conditions began in 2013, and I'm certainly not trying to minimize what he's been through, but I'm not sure that I see enough information here that would justify to me making an exception to the bar exam requirement because of health conditions. There are a lot of individuals who go into inactive status because of health conditions. And I don't know that when we're looking at a period of time of more than almost 2 years of delay in what would have been required to be filing, if we've got enough here to justify the exception of the bar exam.
Well, and that's a valid point.
Yeah, this is Tamika. I was going to say, from my perspective, if we approve this, then it would make every decision after this more difficult, right? Because it would be a more ad hoc approach than having a rule that we were trying to follow.
And I think whatever we do with Mr. Green's petition, it kind of dovetails into the next matter on the agenda. I mean, how are we going to address these petitions in the future? You know, do we want to have kind of a running list of things that we look at when considering whether someone's entitled to relief and not having to take the bar exam again? Do we need to have guidelines to consider? But just to keep us on track on Mr. Green's individual petition, is there any other comments or concerns regarding his request?
Joshua, Malcolm, I have a question.
Okay. You have the floor.
Was for the staff or for the committee chair, was he offered the opportunity to address this committee personally if he had wanted to? I know in some other settings folks speak to the committee directly. Was he given that opportunity?
Hey, this is Tammy. I know I spoke with Mr. Green early on when he called, questioning what he needed to do. And, I did tell him, this would have to go before the committee and he could, make a request. And I always do tell them that they're welcome to attend the meetings, but I didn't hear back from him in regards to that. So, but yes, we always let them know that they have the opportunity if they would like to address the committee.
Okay, thank you for that. The only other thing I'll say, Chair, is I agree too. It would be helpful, at least for me, if almost like there was maybe not a checklist that there's 14 things, and if you get 7 of 8, but it was almost like if we had a list of factors that this committee has considered previously. At least for me, that would help me feel better about knowing we're trying to be consistent with other folks. So thank you.
That's something that we can work on in between quarters, provide some guidelines to make sure that we have consistency. I think that's something that I was going to recommend once we get to the next item anyway, just to, if there are issues that come up with people who are being prevented because of the elimination of the grandfather clause, that we need to have some sort of guide for consistency on dealing with that situation. I'm a fan of a not having too big of a gray area if we can, and so I'm not sure that the rule was written to give us too much of flexibility in waiving some of these requirements. So we'll need to examine that. But the one from last year seemed, with more exigent circumstances due to the pandemic, seemed more ripe for an exception than potentially this one is. If the rule is the rule, then I agree. I think some of your comments are right on about needing to enforce it.
Do we know how many people are taking the bar exam again after being inactive longer than 7 years?
Honestly, Tammy might be able to tell you. I'm not sure many people have done it. I think that is such a deterrent that I don't know many. I don't know any off the top of my head that have become readmitted or reinstated through the bar exam process.
Neither do I. I don't.
Okay. Any other questions or comments?
Mr. Chair, just a question on the form we've got in our agenda. We have 4 options: approve the request, and then bar exam requirement and deny. And I'm not certain of the difference between number 2 and number 3. Wouldn't denying his request to complete CLE requirements in lieu of the bar exam in and of itself require him to take the bar exam to be readmitted?
Peter?
I think the bar exam requirement line would essentially be, it's like approving upon satisfying noted requirements. So we'd be approving upon satisfying the bar exam requirement to be readmitted. Denying would be, a straight denial, which there's not necessarily a reason for that as well.
Then if it's appropriate, Mr. Chair, I would make a motion that we approve upon satisfying the noted requirements, including the bar exam.
We have a motion on the floor. Any seconds?
Second.
Okay. We have a motion and a second. Any additional questions or comments? And just so we're clear, Scott, your motion is that he would be approved for readmission upon taking the bar exam and meeting all the other requirements.
That's correct.
Okay.
This motion carries 17-3.
Okay. Thank you. Turning
18.
to
Okay.
the next item on our agenda is a discussion about the rule change that eliminated the grandfather clause based on a letter from a Ms. Seidel, who, as I understand it, has not filed a petition seeking relief from the bar examination requirement, but has sent a letter, and the topic is up for discussion. What do we do with folks that, when they went inactive before 2011 and did not realize that the grandfather clause was eliminated last year?
Yeah, this one is this one's tough. Ms. Seidel was looking at about to begin taking her 84 hours or so of CLE that she was going to have to take to be reinstated, and then went to look at the form and saw that that the rule had been eliminated. There's some difficulty in this situation because inactive lawyers are not receiving the journal, so they're not necessarily able to see that the rules have changed. The website certainly was showing the proposed rules and the rule changes, but it is perhaps incumbent upon this committee to consider putting in a little bit of a grace period here and getting a message out to anyone and say, if this rule has changed, if you want to seek reinstatement using the other, the CLE requirement, you need to do it by a certain date. And then, so at least the knowledge is out there for people to know if that's something that they want to do. So I do think that there's some, I have struggled with this. I have difficulty with it and empathize with Ms. Seidel and those who were inactive under the assumption that coming back would be a CLE requirement and not a bar exam requirement. And so it's difficult. Yeah.
I think Bert has his hand up.
Actually, I had two questions, and Tom just had one of them. Mr. Langen, did the bar ever send a letter out to all the inactive lawyers informing of that change? That was one of my questions. And the second one was, how long has this grandfather clause been around? Is this like decades?
So the grandfather, to your second question, the grandfather clause was in there for about 10 or 11 years. So when the rule was passed, they essentially said anyone who is inactive after this date has to take the bar exam if they're out for more than 7 years. And so this would only affect anyone who went inactive prior to 2011 and is seeking to return without having to take the bar exam. To your first question, we did not get a letter sent out. It's our intent to do that. one of the problems with inactive lawyers is that we don't know if we have their correct addresses or emails because things change in those. This would be anyone was inactive in 2011 or prior. So it's at least 10 years ago that they've been dealing with the state bar. And so trying to ensure that we have even any kind of appropriate email or address is going to be difficult. But I do think that there would be some value in doing that as a notice type requirement. And then we, set a date and say, in that letter, you need to, apply by this certain date if you want to exercise this opportunity to become active through CLE instead of the bar exam. And our best efforts would be to send it to the contacts the addresses that we have. And so,
Mr. Chair, I think, Mr. Chair, I think Peter has just showed. I would agree with Peter's way, the way forward. I think sending such a letter and determining what that date is, whether it's a year or not, just throwing it out there, I think we would at least fulfill some type of due process for these individuals. And I think that's just the fair thing to do. So I would, although I don't know if Peter's saying it in the sense that he supports it or not, but I think he has just expressed the way forward. Thank you, sir.
Thank you. I think, Tom, you had your hand up.
I did. Peter, how do you address her argument that she has a vested right to come back in without taking the bar exam?
Well,
what do you tell her when that's what she's going to be claiming?
Well, I agree with her to an extent that it's when you're grandfathered in, you don't typically expect that to be then taken away from you. But I think that the process that maybe I just said and Bert talked about would kind of satisfy this for her, give her that ability to come back in without the bar exam. But the rules, our rules go through a process, and they're publicly known, and they're published, and they're approved, and there's comment period, and there are at some point there's going to be rules that were in effect when you were inactive that are now changed, and you're subject to whatever the rules are coming back. And so I understand and empathize with it. I don't know the actual legal basis, whether has a legal vested right in it or anything. I have not given that enough thought. We received this letter from her relatively recently, but I think there's a solution somewhere in between to say, well, we're going to give you a little bit of time and put everyone on notice, and then at some point we've got to move on. Yeah.
Mary, I think you raised your hand. You're on mute. Mary, I think you're on mute.
I'm sorry. When was the grandfather clause eliminated? I know I've heard and I cannot recall.
Tammy, I think it was last year, correct?
Well, actually, the Supreme Court just approved it in December.
Yeah, they approved it. It went in. It was approved by the court in 2021, near the end of 2021. So just recently went into effect. Yeah.
To address this issue, or at least try to generate some consensus, do you think it would be helpful if we tabled this matter until the April 2022 meeting to give staff council a chance to at least come up with a proposal or some guidelines for us to address this situation in the future?
Yeah, I mean, it's certainly a possibility. I think maybe, to come up with a correct time frame to allow, a grace period type thing. Let us give that some thought. But I think it might be beneficial if the committee would give us at least some authority in, Ms. Seidel's case or, cases that arise in between meetings to allow those that would have been able to do CLE, but not for the elimination of the grandfather clause, to allow them to go forward with that process at least this quarter until we come up with a better proposed plan for dealing with that, with it for the rest of the year.
So, Joshua, Malcolm, two things. One, I think I too agree that it seems like we need to provide, at least as a minimum, to staff some pathway to resolve this with her. I don't know that it makes sense, at least if it were me, to wait to hear until April. And then second, I don't mean to put him on the spot, but Judge Rader, would you mind sharing your perspective of this in the interest of fairness? Wouldn't it seem to you?
Well, I think speaking about Miss Seidel's case in particular, I was sort of impressed that this is a person who somewhat stays abreast of changes in the law and knew that she had access to the grandfather clause and was relying on that. And I think she appears to have acted in good faith and relied in good faith on the grandfather clause, and was totally unaware of this change. So I'm somewhat sympathetic to her. But I realized with the change in the law, I overall, I would agree with Peter's recommendation that I think we need to come up with a way to try to at least give notice to all these people who were inactive prior to 2011 and say, grandfather clause is going away. This is a major change. If you want to be restored to active status without taking the bar exam, you need to do it prior to whatever date that is, April 2023 or whatever. So, I mean, if I had to make the call, it would probably be to tell Ms. Seidel that the state bar and the administrative committee at our direction is developing a policy on that, and that she will most likely be able to do the CLE and avoid taking the bar exam. That's probably where I would go on it.
Any other questions or comments? Bert, your hand.
Yes, Mr. Chair. Not saying that I'm pushing for a decision today, but at the same time, not knowing if this really needs to go to the right, could we agree as a group that the letter needs to be sent to all the inactive folks that this would affect with the last known address, and then just give the staff the authority, sort of like a minimum 90 days notice to a maximum a year, and allow them to go ahead and make the call and move forward with this, just to give them some clear guidance, because 3-4 months is a little bit of period of time, and it looks like that this change is now implemented, and I just didn't know if we could give them that, give the staff that much leeway. That's all.
And just so I'm clear, during whatever grace period we provide for, they would be required to take all of the CLEs that they ordinarily would be required to.
Are you asking me? Yeah. I mean, anything that was required to under the grandfather clause. Yeah, that's what.
Which, excuse me, if I can, this is Tammy. Hey, yes, which would mean they would have to take these 84 hours of CLE. It was capped at 7. And, I'd just like to say, I mean, I feel like this is a lot of this responsibility falls on me. I feel like, it's me and my department that has, that needs to notify these folks. And we didn't get an opportunity to do that. If unfortunately, it fell at a really crazy busy time, which is no excuse, but still, I would really like the opportunity to get something out to these folks.
I'm assuming most of the, or many of these attorneys went inactive during a time frame where they had email addresses. You don't necessarily have to put a letter in the mail to them.
Well, we should have email addresses for most of them, whether they are still good. We don't know, just like we wouldn't know if their home address is still good. I mean, they should update them whether they're active or inactive, but they don't always do that. But we could try to send a letter and email, to notify them. That again, this was really just approved by the Supreme Court on December the 14th. So we've really not had a lot of time to deal with it.
Would it be appropriate? It seems like since there's a fairly limited number of people that would fall into the category of folks that were subject to the grandfather clause and are now seeking reinstatement without taking the bar exam, that we could maybe have a motion that this committee passes, that the committee will consider requests to be excused from the bar exam for people who are in that circumstance and did not receive notice of the state bar's change of rule, or the change of rule adopted by the Supreme Court in December. And if in those instances, those people apply for an exception, that those will be considered on a case-by-case basis. I just don't think we're going to have that many of them. I don't know that we need to take a broad action. For most people who went inactive more than 10 years ago, they're not likely to become active again. And so I think we're looking at a fairly limited number of people. Obviously, Ms. Seidel's one, but I'd be surprised if there's more than a dozen more out there.
Well, it's pretty shocking how many of these that we do get in. When we knew that we were waiting to hear back from Supreme Court, anybody that most of the time they will call and kind of say, it's been this long, what do I need to do? And so, of course, we tell them, and anybody that was calling around this time frame, we were like, no matter if you've done any CLE, get your petition in, let's get it in for the end of the year, because this is more than likely may take effect after the first of the year. And I probably have 6 on my desk right now that have been stamped received, but have not, completed their CLE. Just for instance, I've got one that went inactive in 2009, one that went inactive 1996, one that went inactive 1999. That's just 3 I'm looking at right now. So we get more of these in than I think anybody realizes. We get more than we think.
Tammy, how big is the pool that we're talking about? I mean, we're talking like 100 attorneys or 500 attorneys. I mean, what's the? How many?
It's anybody who was inactive prior to 2011, and so
Okay.
unless they're not practicing anymore or dead, I mean, it's a pretty
okay.
It'll be generally thousands of lawyers that went inactive before that in theory could return. But I mean, you're right. There's a smaller pool of likely people who would return, but we wouldn't be able to differentiate. And so that would be, do you email or send a letter to someone who went inactive in 1984, who's we don't have listed as deceased yet, And so I guess in theory, we would send them an email because we don't know that they might want to return. I mean, you'd have to kind of just pick and choose, I guess.
But we just do the best we can.
That's right.
With the last available information. So, I mean.
Tammy, let me ask a question. Would it be possible to post a notice like in the Bar Journal, kind of like a service by publication to kind of a CYA? Well, you didn't have my address. I didn't know, but at least you can say, at least we tried to give some notice to the people who you may not have a valid email and or hard copy address.
Yes, sir. I think that's possible to do something like that, and even post something on our website, just like if this, if they go out and look at it now, they would see this is happening. So they need to get on the move and do what they're going to do.
You might also post with local bars.
That's a great idea.
Any other questions or comments about where we are? Mary?
Yeah, I'm getting the gist from hearing the comments that we think that we need to give folks some notice that have been in this particular lady's circumstance. So is that kind of, we're leaning toward giving her, because she only sent that letter, I think it was like the 10th or 11th or something of January, not very long ago. So that go ahead and give her a break on this. That's kind of what the gist is what I'm getting here.
Yes, she hasn't actually, filed a petition yet, but I think that would be the intent was, she'd be an example of someone who, now that she's contacted us, claiming she wants to seek reinstatement, that we'd allow her to do it through the CLE process instead of through the bar exam process. And I agree, and I don't know who if there's been a motion on the floor, but I do think that just allowing us to give the staff the authority to send the best efforts of notice out, and with whether it's 6 months or a year or something of a time frame to say that they must contact us within this time frame to that they are seeking reinstatement, and to be able to do it through the CLE process and not through the bar exam.
Peter, and I think you answered my question, but if an attorney in Ms. Seidel's class applied for reinstatement through that process, would it still go in front of this committee to determine if there was good cause to waive the bar exam requirement, or would she just be in a position of taking the CLEs and then returning to active status?
I think the easiest path forward would be to create the time frame, and if someone wants to seek reinstatement within that time frame, then they can do it through the CLE process. Otherwise, you delay their ability to either, one, start their CLEs, or two, start studying or signing up for the bar exam if we have to approve it. So I'd like, for whatever short period time frame we agree on, whatever the time frame is, the ability to allow anyone who was inactive prior to 2011 who's seeking reinstatement to do it through the CLE process through this time frame once we send out the notices.
Okay.
But that would be the easiest way for us to do it, and then have a hard cutoff and not do it anymore after that.
Okay. Do I hear any motions?
Mr. Chair, I'll make a motion that we, as Peter set forth, that we request that State Bar staff send out notices to all of those folks using their best efforts to contact them at last known addresses and email addresses, and that this committee set a hard date of, and I'm looking to you, Tammy, and Peter too, of June 30th of this year. That's six months, or July 31st, which is, I guess, a full 6 months from the end of this month, for people to apply, and applications or petitions that are received in that time and who were otherwise subject to the grandfather clause would be able to petition for reinstatement after completing only the CLE. Is that a sufficient period of time, do you think, Peter, Tammy?
I think that's fair. I think that's a fair length of time.
That gives us time to get out notices. It also gives us time to put something in writing in the Bar Journal, in Lawyers Weekly, wherever we can do, on the website for the State Bar, places where we can assume people would look if they were beginning to contemplate trying to petition for reinstatement.
Yes, sir. Sounds fair.
I would just think about, it's January the 20th right now. How long do you think it will take you to get the notices out in all of the places, right? And then people need to contemplate, does this make sense? I mean, maybe they will just say, even if I'm thinking about it, I need to go ahead and write a letter, but it's really not, I don't know. I don't know.
No,
That seems
I
like
agree with you, Tamika. We wouldn't flinch at it being a little bit longer of a time, whether that's by, maybe you guys could give us the authority to say it needs to be done before the October meeting of the State Bar, and And that gives them a little bit more time. It gives them one extra meeting to get this stuff in and more time for us to figure out the best way to get all this information out to everyone.
How about like no later than 31 December? And then the staff can decide on the date. I just like to give the staff as much flexibility as possible while taking Tamika's considerations.
There's a motion on the floor for July 31, 2022. Scott, would you be amenable to modify your motion regarding the due date?
I would. Let me then ask Peter and Tammy, would you prefer for the action of this committee to be to give, as Bert suggests, give you the flexibility to set a date, or would you prefer that we set a date? And if so, then I'm happy to modify my motion to reflect the no later than the October 2022 Bar Council meeting.
Yeah, I would prefer that the committee set a date, just because it's easier enforcement mechanism to have the committee make a date than, have us randomly pick one. I would prefer, by the, petitions need to be received before the October meeting, I think is a fair compromise. Yeah.
Then, Mr. Chair, I would amend my motion to reflect no later than the October meeting of the North Carolina State Bar Council.
The petitions would be received before the commencement of the October 2022 meeting.
Correct.
Do we have a date certain on that? I just like date certains more so than.
Yeah, we do have a date on this one. We can pick, let's see, what do we got? October 2022 would be
25th.
October 18th.
I think
that's the beginning of the October meeting. So maybe you should pick Friday, October 14th, which is the Friday before the October meetings.
Yeah.
Okay.
Would that be okay, Scott?
Absolutely.
And the petitions would not only have to be filed by that date, but the CLE requirements would have to be met by that date as well. Is that?
I don't think that is necessarily the intent, that they just need to begin the process for reinstatement, Yeah.
I wasn't clear on that. Okay.
Do you need me to restate the motion, Mr. Chair?
That might help, just so we're all on the same page, or so I'm on the same page.
I'll give it a shot. My motion would be that the committee direct State Bar Council staff to use their best efforts to contact those who would have qualified for the grandfathering up to the change of the rule at the end of December of last year, using mailing and or email addresses to notify them of the rule change. And that if anyone who falls into that category were to have their petition filed no later than the close of business on Friday, October 14th, 2022, that they would be able to petition for reinstatement utilizing only or without the requirement that they take the bar exam, but through the CLE requirement only.
Second.
We have a motion and a second. Any additional questions or comments? I think we're ready for a vote.
That is unanimous.
Motion carries. All right, turning to Roman numeral 5A, these are folks that are petitioning from reinstatement from suspension that have been reinstated by the secretary due to meeting all of the requirements. There's no action to be taken on by the committee. 5B, we have an applicant that is petitioning to be reinstated and then is petitioning to seek immediate inactive status, which correct me if I'm wrong, this is somebody that may be wanting to avoid the bar exam requirement by activating their license and then immediately going to inactive status.
That's correct. That's one of the reasons that this happens. If you look at the time frame, 2015, 7 years, be able to come in active and go inactive again. Yeah.
Peter, has the committee typically allowed these petitions?
There's no reason not to. I mean, it's there's no requirement that you come into that you're coming back to work for a certain period of time. Tammy does have some comment on this one, I think.
Okay, Tammy.
Yeah, what I can add for her, I think her motivation is she needs a certificate of good standing. I think maybe she may be trying to get licensed in another state or something. And because her license was suspended, until she cleans up the suspension and returns to a good standing, she cannot receive that from us. So that's another motivator to clean up the suspension, take care of the things that she didn't take care of, and then she's just going to put her North Carolina license on an inactive status. So, but you're right, there's nothing preventing that revolving door either.
Okay. So she's asking that her petition be granted upon satisfying some financial requirements by the April 2022 meeting.
That's correct. And I also did receive today her notarized page as well. So I do have that. So we're just waiting for the financial piece of it. And I think that'll take care of what she needs.
Okay. Any questions or comments?
Sounds like good lawyering.
Okay. We'll entertain any motions.
Make a motion that
Motion
we,
to approve.
go ahead.
Oh, motion to approve upon payment of fees by April.
We have a motion from Judge Hennett, and I think Judge Rader, I'll take your
Right.
comment as a second.
That's right. Thank you.
Okay. Any additional questions or comments?
That's unanimous.
Okay, motion carries. Roman numeral 6A are petitions for pro bono practice by out-of-state attorneys who would be acting under the supervision of Ms. Merle from SIGA or Pisgah Legal Services. I can never get the correct pronunciation. Do we want to take these as a group?
Yeah.
Okay.
I think just for the new members that you are allowed to get a pro bono practice. We allow lawyers from out of state to participate in legal services, legal aid, Pisgah, if they have if they're being supervised by a responsible lawyer, just as an incentive for people who maybe have retired here in North Carolina to participate in pro bono services without being licensed here.
Entertain any motions?
Motion to approve.
Okay, there's a motion on the floor. Any seconds?
Second.
Okay, we have a motion and a second to approve Ms. Glass and Mr. Hoffman who want to volunteer their time.
That's unanimous.
Okay. Roman numeral 7A is a petition from Mr. McAllister, who is wanting to relinquish his membership in the bar, which is, I think, a fairly new status. It's a little bit different than going on inactive status. Peter, could you?
Yeah, this is a relatively new procedure. A few years ago, we had a lawyer who did not want to be associated on the rolls of the bar anymore. Did not want to be considered as an inactive lawyer, actually wanted to not be considered as, a member at all of the state bar, not an inactive or active member, just not a member, completely removed from the rolls. And we determined that it was actually proper to us to have this option as a due process, freedom of association type thing. If someone does not want to be associated anymore, there should be a way for them to permanently remove themselves. But what this means is if they relinquish their membership, if they want to become members again, they have to apply through the Board of Law Examiners as if they were not ever practiced, had never practiced before. So it's full removal from the rolls. There's a process for that and a form for that, and we now allow it.
And Peter, is it made clear to people that are applying for this status that it is not an active status? It's not a matter of them taking some COEs if they change their
Yes,
mind?
yeah, it's very clear. Very clear that this is a different path to take than inactive status. And we are actually one of those states where if you are inactive, you don't have to pay any money. And some states charge you to be inactive, but North Carolina, there are no inactive dues. And so there's really, there's not much incentive to do this full relinquishment unless you have a real, reason that you want to remove yourself from the rolls. And so it does not happen a lot, but we have three this quarter.
Bert, you have a question?
Yeah, just real quick, just curiously, do they have to actually turn their license back in, like the original license that they have it, like mail it back in? I'm just curious from a procedure standpoint, and I'm being nosy. So.
I don't know, Bert. I don't know what we've done, but I think the first guy actually did mail his license in. He was done with us, and so for whatever reasons.
I was just curious. Thank you.
Any other questions or comments?
I will just say to the committee, if I can, every time we get one of these in, we do reach out to the lawyer just to make sure they know the difference between the relinquishment and the inactive status. And actually, we had received a couple more, and when we reached out, they really, I guess, were confused or didn't know the difference and decided to go the inactive route because, I think it's just pretty sad that they want to relinquish their membership. And but anyway, so we are thinking about. We didn't always have the petition out there. We used to have them to just kind of write something up if they wanted to relinquish. So we may remove it. It's causing quite a bit of confusion, I think, to some point. So if they really want to relinquish, they reach out to us usually, and we tell them what they have to do. I think having both petitions out there, or sometimes they're missing the inactive and maybe for whatever reason, just see the relinquishment petition and fill it out. It just seems to be causing a little bit of a confusion. But because most of the time when you call, a lot of times they'll want to go the inactive route. So something just to think about. But
What are some of the reasons that you've been given as to why a person would choose to do this?
Well, I know one reason, Kathleen, was there was an inactive lawyer who wanted to be appointed to a position on a board in Hawaii or some other state, but it was a non-lawyer position on a board. And they were being, when you search their name on our website, they came up, and it was, they wanted to not be considered a lawyer in any way. So they wanted to be able to be eligible for that board position because they wanted to be fully relinquished, something like that. There also could just be disagreements about policies or statements or the actions of the bar, and maybe you're disgusted with the profession, or it's no longer something that you want to be associated with. But there isn't it's not, you can't do it in a way to escape discipline or escape the grievance process. There's no, you're not allowed to kind of resign before getting fired kind of thing. So it's Someone who had strongly held belief that they want to be completely disassociated with it.
Okay.
Good. Any motions with regard to Mr. McAllister's petition?
Move to approve.
Do we hear a second?
I'll second it.
Okay, we have a motion and a second. Any additional comments, or is everyone ready to vote? The motion carries.
Unanimous? Yep.
Okay. Unless I do not hear a strong objection, I would ask the committee to consider Roman numeral 7B, the two petitioners together. They are petitioning to be removed from the rolls of the attorneys of North Carolina, subject to paying $28 and then $48.
I would make a motion that we approve upon them satisfying the requirements by the April meeting.
Okay.
I'll second.
Any questions or comments?
That's unanimous.
Okay. Roman numeral 8 is a proposed amendment that would allow the secretary to transfer attorneys to inactive status without action by this council. Is that correct, Peter?
Yeah, so this is something we were thinking about in a similar vein that we have the secretary's ability to transfer someone to reinstate someone from inactive status in between quarters if all of their requirements are met. In this age, to speed up process if someone wanted to go inactive, to have the authority from the rules to allow the secretary to do that same thing, just in reverse, to transfer someone to inactive status if all of the requirements are met in the discretion of the secretary in between meetings and report that to the committee in the same way we reinstated in between quarters. It's just a mirror of the rule, just flipped. Yeah.
Okay. Any questions or comments? Would entertain a motion?
I would move to, I would move to amend the amendment 1D rule 0.091 transfer to inactive status.
We have a motion. Is there a second?
Second.
Okay.
A question, does the Supreme Court have to approve this?
Yes, so the process here, this will go to the executive committee and then to the council, then for publication, and then once approved, go to the Supreme Court. Yeah.
Okay. Any other questions or comments? Okay, I think we're ready to vote.
That's unanimous.
Okay. And last but not least is a request to issue either show cause notices or suspension orders to the attorneys listed on the final attachment to our agenda. These are folks that have fallen out of favor for not paying dues, CLE fees, other related requirements to maintain their law license, and they would have received notices last year about their non-compliance and have not brought themselves in compliance. Sure, I'm leaving some things out, but Peter, is there anything else we need to know before acting on this?
Well, that's correct. Just to give us the authority to issue these, assuming that various names have not been cleared up by Friday, that we will continue to try to clear these names off before issuing these notices, but just have that authority to do so.
Mr. Chair, again, I would move to approve the issuance of notices to show cause and suspension orders. Thank you.
Second.
We have a motion and a second. Any other questions or comments? Okay. Think we're ready to vote?
And that is unanimous.
Okay. Unless I'm missing an addendum, I think that is our agenda for today. It's been a pleasure seeing everybody, even though it's been on Zoom. I look forward to getting together hopefully in April.
Thank you, everybody. This is the longest administrative committee meeting that we've had in a long time, and but I think it was important. It was important that we got these things taken care of. So thank you for your help.
All right.
you.